Court calls the case of the people versus Shabab Jackson.
We're ready in that matter, Your Honor.
Laura Willenbring for the people.
Mr. Jackson, could you state your name for the record, please?
Shihab Jackson.
Your Honor, today is the date and time set for the probable cause conference. My client respectfully requested this matter be set for preliminary examination at the earliest possible date.
April 4th, 2023, 9 a.m. before me.
What happens before now and then with concerning bond?
You're out on bond now, Mr. Jackson. Is there some aspect that you want to have addressed?
Yeah, I have to. Well, it's Ramadan right now, and I have religious obligations as well as work obligations in general. And for some reason, it wasn't a drug case or have anything related with drugs. And I'm on what do you call it? The daily reporting thing. And I believe I may have. I think I missed mine yesterday. I don't mean to be in violation, but I'm just sort of struggling with that and confused as to why that is.
Your Honor,
if there's a way to lessen that, or like I don't see the reason for being on.
When you look at the situation honestly, it's easy to understand why the court requires regular drug testing. These conditions weren't added to inconvenience you. They were put in place to make sure you stay on the right track while your case moves forward. And it's important to remember that these rules are part of the bond agreement that allowed you to remain free instead of waiting for trial behind bars. By accepting that bond, you gave your word that you would follow every condition attached to it. So if you want to keep your freedom and avoid creating even more problems for yourself, the smartest thing you can do is follow those requirements exactly as you agreed to when you were released. Not doing so only risks your own future and gives the court a reason to question whether you're willing to take responsibility for your choices.
Your Honor, having heard what Mr. Jackson has stated, we'd ask that the tether aspect or the drug testing aspect actually be reduced in this case or dismissed in this case. As he stated, there is no drug aspect to this case whatsoever. And this just serves as an added burden on him.
He's on intermediate supervision.
I'm not sure why.
I'll handle it, Mr. Jackson. I got you.
As set by the magistrate back in the beginning of March. I'm disinclined to change that at this point. I guess I'm not sure why his testing, why Ramadan would interfere with his testing. I understand that he may have certain obligations, but I have other individuals who are engaged in the celebration of Ramadan who aren't having these issues.
Well, it's not celebratory, sir. I just fail to see the connection with the nature of my case and having to go out of my way and pay money that I really don't have and time that I don't have to.
That's exactly how bond conditions work. When you're facing criminal charges, the court has to take certain steps to make sure you don't disappear while your case is moving forward. Because of that, they put rules in place that you must follow in order to remain free. One of those rules in your situation is regular substance testing. It doesn't matter if it feels inconvenient or time-consuming, because it isn't something the court is casually suggesting. It's a mandatory part of your release terms, and if you want to stay out of custody while waiting for trial, you're expected to meet every requirement that was explained to you from the beginning.
That's not a basis for me to change it. I thought that what he was indicating, because he had started out that it was Ramadan, and I thought that there was some interference with what he had to do, but I'm not changing it. Mm-hmm. I'm going to leave his bond as continued. We can see him on the 4th.
Thank you, Adam.
So is it not possible to amend the drug testing, Your Honor? I understand is it just a...
Okay, so hold on.
Yes,
hold
sir.
on. I think I already said that, and I wasn't going to say anything. I will make, Ms. Willenbring, I'll make all the changes that you want. I'm just going to tell you something, sir.
Yes, sir.
I will do what I can for people. I am also very those that work around me. I got a message that you were very insulting to my clerks. So
To who?
you ought to be that I'm
Mr.
letting
Jackson,
you.
stop talking.
I can't hear. I'm just seeking clarity, sir.
Mr. Jackson, stop talking.
I'm not talking, sir.
So
That's what you just did.
see, it's that attitude that's the problem. So what
Sir,
I'm
a
going to
young
do
black
is I
man
will.
fighting for his
Jackson,
life.
not
Attitude. I'm listening.
You need to be quiet.
When the judge tells you to be quiet, it means exactly that. Stop speaking and let the proceedings continue. It does not mean keep interrupting until the court has no choice but to hold you in contempt. And you should remember something important. If you're found guilty of criminal contempt, that can also count as a violation of your bond conditions. Once that happens, the court has every right to revoke your bond entirely and place you in custody for the remainder of your case. Following the judge's instructions isn't optional. It's a direct requirement tied to your ability to remain free while your charges are pending.
Sir,
Mr. Jackson, let the judge talk.
I understand. I'm not sure if there was a mute or something. I'm just making sure. I understand.
Okay, so you don't have to respond to everything that's said. You don't have to get the last word. That's not.
I'm not trying to. My life is on
Okay,
the line here.
all
That's
right.
all. That's all.
Okay, you know what? You know what? Put some deputies at that door right now, right down there at the door. Because he apparently just called security to get him down at that door. Because apparently he doesn't want to listen to his attorney. He doesn't want to listen to me.
Sir, I'm just seeking clarity on the matter. That is all. I promise. I'm a black man in the system, just trying to fight for his freedom. That's all.
Okay, so am I. So
You're
don't
not
even
fighting
try
for your
it.
freedom,
Don't
sir. With all
even
due
try
respect.
it. Don't even try it.
Don't even try
Alan,
what,
get
sir.
down there.
Tyree
Get down
Lee
there.
was forced
Get
black
down there,
officers
Alan.
beat black
Just
people
get
to
down
death,
there.
sir.
Take him in.
Judge Simpson is the last person you should accuse of showing bias. He has a strong reputation for being fair, patient, and genuinely compassionate toward the people who appear in his courtroom. He treats everyone with respect as long as they show respect in return, and I've never seen him make a decision, good or bad, based on anyone's race or background. And yes, this is the same Judge Simpson we're talking about, the one who just instructed the bailiff to go bring someone back into the courtroom. That individual chose to behave inappropriately in a nearby room that was set up specifically for virtual court sessions, acting as if the rules didn't apply to him. The judge wasn't going to ignore that kind of behavior, and based on the situation, the moment for that person to quietly walk away without consequences passed about 10 seconds ago.
Sir, I'm going to find you in contempt for interrupting the court.
I'm not
Mr. Brown, if you've got somebody down here,
Sure,
he
I'm
can
just
come in,
saying.
he can see me in person. We'll wait for a prosecutor to get down here and I'll deal with this in person. I'm passing it right now, but right now he's being taken in because I'm not dealing with
What
him.
if I,
I'll
Sir.
pass this matter.
sir?
Mr. Jackson, if you will just maintain your.
Court does call the case of the people of the state of Michigan versus Jessica Lynn Kyle.
Mr. Ganatra, first Assistant Prosecuting Attorney, on behalf of the people.
Zachary Ward on behalf of Ms. Keel, Your Honor. Can we approach very briefly on this matter?
You really want to go into a room with me
Your
right
Honor,
now?
Your Honor,
Sure,
I don't
fine.
think.
Yeah,
Your
give
Honor,
us a bench copy.
Your Honor.
Put Mr. Ganatra and Mr. Ward into a room with me.
I was watching Judge Simpson closely, especially after he firmly addressed the earlier outburst from that defendant. What stood out to me was how quickly he regained his composure afterward. He didn't carry any frustration into the next case. He immediately shifted back into a calm, lighthearted tone for the attorneys who followed, treating each person with a fresh start. Later in the docket, the same defendant returned to the courtroom, and this time he finally did what everyone watching had been hoping for from the beginning. He remained quiet long enough to let his attorney speak on his behalf. By stepping back and allowing his lawyer to take control, he finally gave himself a real chance to be properly represented.
Calls the case of the people versus Shahab Jackson.
Leggett, Senior Assistant Public Defender, representing Mr. Jackson. Mr. Jackson, would you state your name for the record, please?
All right, we're here. I set this already for preliminary examination, and it didn't seem to me, quite honestly, that the defendant was being cooperative with anything, and I didn't know what his problem was. And so I was considering revoking his bond and having him sit. But I would like to give him an opportunity or have counsel explain to me what's going on with this young man, because the behavior was unacceptable.
Your Honor, I've had an opportunity to talk to Mr. Jackson, and I want to start with that. We did talk about, and I was able to explain to him what contempt is considered in court. We went over that the definition is a willful act, omission, or statement that tends to impair the authority or impede the functioning of the court. In the course of our conversation, I learned that in 2015, so approximately 7 years ago, during Ramadan, Mr. Jackson was incarcerated and his grandmother died, and he was unable to get a pass, go to the services, spend any last few days with her. And so this time frame specifically is very triggering, but definitely with him being involved in court again. He has indicated that he would allow me to do the talking today to demonstrate just what he's doing right now. And so with that, we are asking that Your Honor give him another opportunity to come into court on his own.
I'm not sure. Should he be given another chance? I'll let you decide. Share your thoughts in the comments while we take a moment to hear Judge Simpson's response. His reaction will give us a clearer picture of how seriously the court is taking this situation, and whether this defendant has actually earned another opportunity or simply used up the patience he was shown earlier.
I'm going to tell you from my standpoint, he kept trying to overtalk me, and that ultimately, and you can tell him, Ms. Gaines, anybody that's been before me, that will never happen. And then, but what was so bad is the person that's trying to help you, Mr. Brown, is trying to get you to be quiet, and you kept talking. And I don't know where you thought you were going to get to, but I can tell you right now, you do that in my court, this is where it leads. I can't tell you necessarily that you're going to listen to your attorney, but you're certainly not going to sit up there and interrupt them. And I'll tell you, I've been doing this for a long time, and when I see somebody that's not listening to their attorney, especially somebody that's esteemed as Mr. Brown, and others telling you what to do, that's a person that's not going to listen to anything. I have to almost believe they're not going to listen to anything I'm telling them to do. Those are the people that end up getting themselves incarcerated. I'm then also very disturbed that you've got defense counsel, and then you're down at the prosecutor's office. I don't even know why you're down there. Well, you're trying to give them something or whatever, and you're trying to give them something, haven't told your attorneys that what you're doing. That doesn't even make any sense. It's almost like you want to get locked up. I will be honest with you, sir. I looked at the charges and see your previous record. I get what may have happened to you in 2015. I see the timing of it when I'm looking at your record, but then I see what you did afterwards. Whatever your thoughts are, you just got to do better. There is no reason coming in here today that this should even be occurring. Tell you what, I'm going to trust Ms. Gaines. Ms. Gaines tells me that I should give you another chance, and Mr. Brown told me the same thing, that I should give you another chance. These are these people you won't listen to, by the way. But if they tell me to give you another chance, I'll give you another chance. But I'm going to let you know you don't have any other opportunity with me to mess up. You mess up, I'm sending you. Am I understood?
Yes.
I'm also going to add so I will continue his bond. He can be released to custody. I have the amended complaint. I am going to also add as a condition of his bond to be entered into lien that you are not to go within 500 feet, except if you're going to, well, that's outside of the 500 feet of the Washtenaw County Prosecutor's Office in downtown Ann Arbor. You understand that? Pardon?
He's gonna get it yesterday.
All right, very good. So we're adding that to lien. So I want you to know what that means. If you're within 500 feet of their offices, police officers come on you, they can arrest you on that. So don't say you didn't understand because I explained it to you. Anything further?
No, thank you.
All right, his bond can continue. He can be released.
All right, everyone, that brings us to the end of the video. It seems that Judge Simpson's compassionate side ultimately guided his decision. And honestly, that was probably the most reasonable outcome in this situation. Based on how this individual has handled himself in court so far, I wouldn't be surprised if we see him facing a criminal contempt issue in the near future. His behavior has shown a pattern, and the court can only overlook so much before taking more serious action.
The defendant has made certain statements about, I guarantee, to use her words, that she will have Mr. Jensen represent him in this case. I have no personal knowledge to any communications they may not have. But again, in light of the age of the case, as well as the defendant's statements on the record, the state does believe a timely administration of justice is especially appropriate in this matter. And the state did issue its subpoenas for the presence of the officer. The officer has taken time out of his schedule to appear here today. And absent any other concerns the court may have, I will tell the court the state is prepared to proceed to trial. But again, acknowledging a defendant's right to counsel in these types of situations, but I'm not sure how the court wishes to reconcile that in light of the prior procedural history of this case and the statements made by the defendant on the record here today.
Well, I don't want to repeat. If I continue this, I don't want to repeat it today. I don't want to hear Miss Phillips. I don't want you to come in and use the excuse that no attorney will come to Butler County, because they do it all the time. I know they will. And I don't want you to sign a waiver. I don't want you to tell me you waive and then you take it back. You either are going to, this is your last chance, you're either going to get an attorney or we're going to proceed, because you have had since 2023 to get an attorney. And you said you have the money to do it. You said you don't want to use a court-appointed attorney. You said something about last time. You didn't apparently like the results of the last court-appointed attorney, maybe. But I'm not quite sure I'm catching everything you're throwing out there. So at this time, very reluctantly, I will continue this bench trial. Because yes, you're entitled to have an attorney, but you are not entitled to use it willy-nilly back and forth to delay proceedings or anything of that sort. So, Jenna, when's our next available bench trial?
Your Honor, I have July 16th.
Okay. We'll put it on July 16th at 1:30.
Your Honor.
Yes,
now,
Michelle.
the defendant is holding some paperwork in her hands. Can she read the case number off of that? I don't know if she's referring to the same case about being arrested.
Oh, okay. Do you have another case you've been here on besides the two we've mentioned today, Miss Phillips?
Yes, ma'am.
And what's that case number?
No, bear with me, please.
Sure. Miss Phillips?
Yes, ma'am.
Please take note. Please take note. Disregard July 16th and take note.
Okay.
Your trial will be July 23rd at 1:30.
Okay.
All right, and at this time, I'm going to let you go, Trooper, unless for some reason you particularly want to stay around.
I appreciate it, ma'am. Have a good day.
You too. Thank you.
I believe this is case number 23 TR 2386.
Oh, that
I believe.
I don't know why that does not show up on the Odyssey history, but that sounds more like the time frame of when you were here before.
And Your Honor,
Yes, Mr. Regier.
what I do show from my notes is that that case was last taken up by the court on December 11th, 2024. And the court did remove that case from the docket at the state's request.
Okay, and was that the speeding one?
No, that one was back in 2019. The one he's talking about was in 23, and that was speeding 91 in a 75, no insurance.
Yeah, because that was the one that.
And no driver's license from July 12th to 23.
Yes, ma'am, because that was.
I'm sorry, Michelle, what was that?
The year of birth on this is 2000.
Yeah.
Okay.
That
So
would
you're
be 25.
Are you saying on the 23 case?
Yes.
Okay, that's probably why the state dismissed it. And now we've got this case.
Okay, so
The 23 case is still pending.
It is still pending. Does it have a docket date?
No.
All right, Mr. Regier, what's the state planning to do with that case? Are you dismissing it?
Your Honor, the state is still in the process of reviewing that case. What I would tell the court is, per the state's request at the last hearing in that case, the state did request that matter be specifically taken off the court's docket, and the court did grant that request.
Well, you may be looking at speedy trial on the 23 case. But I do know that the defendant had several, as I was looking at the docket notes, she did have at least a couple of failures to appear. And I remember she herself was here telling the court that it was not her. Well, Mr. Regier, we can't just leave the case sitting in limbo. We need to either get it on the docket or get it dismissed. What do you want to do?
One moment, Your Honor.
We could set it on that same docket that we're setting this one, July 23rd, if you want. And then we can resolve it one way or another.
No objection to setting that case on that same date if that is the court's order, Your Honor.
Okay, so Ms. Phillips, you might tell Mr. Jensen we have two cases on that docket.
Yep.
Give him that 23 case, and I'm going to set that for trial too, Mr. Regier. So have your witnesses ready for that if you're going to go to trial. And let's see, we have the defendant on. Let's see. Let me check one other matter.
Okay, so the 23, I'm sorry, the 23 case, when you say 23, you mean 23 TR 2386? Okay.
Yeah,
okay.
Apparently when it was taken off the docket, the state did not put it back on the docket, and it's just been kind of sitting out there, running the clock, as they say. So I'm going to put it. I'm putting it on July 26th or 23rd at 1:30 also.
Yeah. Okay, so was this failure to appear on that speeding?
You've had failures to appear on both of the pending cases. In this case that we came to court on today, 23 TR 3395.
Yeah, that was the one I was never served a subpoena on because I showed up. I was here on the date on the ticket.
Hold up. I'm going to answer your question.
Yes, ma'am.
September 4th, 2024, you failed to appear for first appearance at a bench warrant issued. Then you were present January 8th, 2025, and that's when there was a discussion about you would hire an attorney, etc. So you had one failure to appear
Well, I
there.
think
Now,